How can we reduce the backlog of cases? How can we reduce the pendency? How can we take away the burden of the apex court? I have 5 solutions. Number 1, we can nip the frivolous litigation at the first instance itself. So the solution is, we cannot come out with a new system and abandon the existing system and replace the new system with the existing system. That is not my solution. My solution is, my humble solution for your kind consideration is, now just now we have seen how the frivolous cases are filed, that dismissal by the High Court against the earlier listing. How this could have been avoided without even approaching the Honorable Court for hearing, without even wasting the judicial time. There is a power vested with the registrar that he can go through the petition. The petition does not reveal the reasonable cause. The petition does not reveal the injustice. The petition appears to be scandalous and frivolous. That petition can be rejected by the registrar itself. Order 15, Rule 5 of the Supreme Court rules. Because the Supreme Court has got the power to frame its rules under Article 145. Based on this rule only, they have framed the Supreme Court rules, and under Order 15, Rule 5 of the Supreme Court rules, which says the registrar can entertain the petition which is frivolous and dismiss the petition without even getting it heard by the honorable judges. But the remedy against that dismissal is, a litigant can appeal to the Supreme Court against the dismissal order passed by the registrar within 15 days. If this power had exercised by the honorable registrar, the SLP against the dismissal of early listing would not have reached the honorable court. So this power, though it is there in the rule book, but I have my own doubts whether it is put in practice. And second solution is National Court of Appeal. Because the concept of apex court and the concept of top court is to render a judgment of public importance and lay down a law for the entire country. Because we all know that Article 141, when there is a judgment pronounced by Supreme Court, becomes a law of the land, and it has a binding effect on all the courts. So it becomes law of the land. In Vishaka versus State of Rajasthan, though there was no law on the point sexual harassment at workplace, there was a gray area, but still Supreme Court invoked Article 142 and framed guidelines. What was the duty upon the employer, the employee, and how the sexual harassment has to be prevented. So those guidelines framed under Article 142 has become the law of the land under Article 141. So the concept is to declare law for the entire country and to decide the most important interpretation of the constitutions, and they are not meant for deciding rent matters. They are not meant for deciding these frivolous cases. So therefore, a National Court of Appeal would be a better option, and it can be established in the eastern, western, northern, southern zones. And the factual finding aspect will become final at the stage of Court of Appeal itself. And those cases will not approach the Supreme Court. Therefore, the Supreme Court can easily spend its judicial time with the most important question of law, which concerns the public at large. Where did I get this idea? The establishment of National Court of Appeal is there was a judgment pronounced by the Supreme Court itself, and they expressed their worries. Frivolous cases are being filed under 136, and we could not spend judicial time for evolving law, for interpreting constitution, for rendering judgments of public importance. So the Supreme Court itself came out with a solution, National Court of Appeal. The judgment is Bihar Legal Support Society versus Chief Justice of India and another. This was reported in 1986, Volume 4 SCC, page number 767. The facts of the case quite interesting, because a writ petition came to be filed by Bihar Legal Support Society. This society is a registered society. The object of the society is to render free legal aid to the poor and disadvantaged people. So they filed a writ petition. The background of this writ petition is on 5th of September 1986, the bail petition came to be decided by the Supreme Court late night Saturday on 5th September 1986 to consider the bail petition of two big industrialists. Their names are Shri Lalit Mohan Thapar and Shri Shyam Sundar Lal. So their petition came to be decided in the midnight. And how that event is related to this Bihar Legal Society case. Considering the urgency shown by the Supreme Court, this society preferred a writ petition by saying the Supreme Court should decide the bail petition immediately, as how they decided the bail petition of those two industrialists. Therefore, how the writ is being treated by the Supreme Court, at the same part, even poor people should also be treated, and their bail petition, an anticipated bail petition, should be decided immediately. So this was their prayer. And the case came up before the Supreme Court, and did you notice the other side was the Chief Justice of India and others. That is the case law. Bihar Legal Support Society versus Chief Justice of India. And the then Chief Justice was Justice Bhagwati. This petition came up before the bench. Bench appreciated the writ petition, and they said the Supreme Court is meant to render justice not only to the rich people, but also to the disadvantaged people, also to the poor people, because poor were deprived of justice for so many years. Therefore, the Supreme Court leaned towards the weaker section and they render justice to them. That is why the concept of PIL originated. Because even before the origin of PIL, the most important is to maintain a petition under Article 32 is locus standi. What is your locus? How is your right violated? Otherwise, if you are not able to establish your locus standi, your petition will get dismissed. But the concept of PIL diluted the locus standi. Even the deprived people, even the weaker section, those who are economically backward, can approach the Supreme Court by writing a mere letter to the Chief Justice or to any other judges. So letter can be entertained as a PIL. Even a suo motu petition can be taken by Supreme Court. So that is how the PIL concept evolved to render justice to the weakest sections, those who are deprived from approaching the Supreme Court. So those concept of PIL was also discussed in this bigger legal society case also. And judges, they said, we cannot frame guidelines or we cannot give directions to the administrative side of Chief Justice, saying that these are the petitions to be decided then and there. But on the judicial side, we deem it fit to say that whatever and whenever the bail petition or anticipatory bail petition is preferred, be it rich or be it poor, if it is preferred before the Honorable Supreme Court, the Supreme Court, considering the urgency, an advocate can have a mentioning before the court explaining its urgency, and if they could satisfy the bench that there is urgency in that matter, then and there it will be listed. And they appreciated, the judges appreciated the endeavor, right-spirited society. They recorded their appreciation. At the same time, they also expressed their consent for National Court of Appeal in this judgment. So, if the listeners find time, kindly go through this judgment. It is one of the most important judgments, and how the judges appreciated the writ petition, and they have explained what is the concept and what is the need for the Supreme Court, and explained that they are bound to decide the constitutional cases, not the frivolous cases, and they explained the need for Court of Appeal. So from this judgment, I took a guidance, and I also reiterate humbly that we need the Court of Appeal to be established. And Vasanta Kumar case is also pending, and Advocate Vasanta Kumar, he has also preferred a case for establishment of National Court of Appeal. Notice issued by the Supreme Court to the Union of India, and it is pending for consideration before the Honorable Supreme Court.